Hello, future lawyers! Let us review the rules of procedure for environmental cases, particularly on the writ of Kalikasan and the writ of continuing Mandamus. The writ of Kalikasan is a remedy on behalf of persons whose constitutional right to a balanced and healthful ecology is violated or threatened with violation by an unlawful act or omission of a public official or employee or private individual or entity involving environmental damage of such magnitude as to prejudice the life, health, and property of inhabitants in two or more cities or provinces. The writ of Kalikasan is a remedy available to a natural or juridical person, entity authorized by law, people's organization, non-governmental organization, or any public interest group accredited by or registered with any government agency. The petition shall be filed with the Supreme Court or with any of the stations of the Court of Appeals. The following pleadings and motions are prohibited in a petition for writ of Kalikasan: motion to dismiss, motion for extension of time to file return, motion for postponement, motion for a bill of particulars, counterclaim or cross-claim, third-party complaint, reply, and motion to declare respondent in default. The reliefs that may be granted under the writ are the following: A. Directing respondent to permanently cease and desist from committing acts or neglecting the performance of a duty in violation of environmental laws resulting in environmental destruction or damage. B. Directing the respondent public official, government agency, private person, or entity to protect, preserve, rehabilitate, or restore the environment. C. Directing the respondent public official, government agency, private person, or entity to monitor strict compliance with the decision and other orders of the court. D. Directing the respondent public official, government agency, private person, or entity to make periodic reports on the execution of the final judgment, and E. Such other reliefs which relate to the right of the people to a balanced and healthful ecology or to the protection, preservation, rehabilitation, and restoration of the environment, except the award of damages to individual petitioners. At this juncture, let us discuss another remedy under the rules: the writ of continuing Mandamus. Continuing Mandamus is a writ issued by a court in an environmental case directing any agency or instrumentality of the government or officer thereof to perform an act or series of acts decreed by final judgment, which shall remain effective until judgment is fully satisfied. It is a command of continuing compliance which aims to ensure the successful implementation of the order of the court for the protection of the environment. In Philippine jurisprudence, the concept of continuing Mandamus was originally initiated in the case of MMDA versus Concerned Residents of Manila Bay, wherein the Supreme Court ruled that the cleaning or rehabilitation of Manila Bay can be compelled by Mandamus. The court then issued a writ of continuing Mandamus compelling 14 agencies of the government, including MMDA, DENR, DOH, DILG, and the Philippine Coast Guard, among others, to each submit to the court a quarterly progressive report of the activities undertaken in order to rehabilitate the Manila Bay. Presently, the rules of procedure for environmental case codify the writ of continuing Mandamus as one of the principal remedies which may be availed of in environmental cases. Procedurally, its filing before the courts is similar to the filing of an ordinary writ of Mandamus. However, the issuance of a temporary environmental protection order is made available as an auxiliary remedy prior to the issuance of the writ itself. As a special civil action, the writ of continuing Mandamus may be availed of to compel the performance of an act specifically enjoined by law. It is likewise available with the writ of Kalikasan should the facts merit such a relief. A petition for continuing mandamus may be filed against any agency or instrumentality of the government or officer thereof on the grounds of unlawful neglect of the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station in connection with the enforcement or violation of an environmental law, rule, or regulation, or a right therein, or unlawful exclusion of another from the use or enjoyment of such right, and there is no other plain, speedy, and adequate remedy in the ordinary course of law. The aggrieved party must specify that the petition concerns an environmental law, rule, or regulation, with a prayer that judgment be rendered commanding the respondent to do an act or series of acts until the judgment is fully satisfied, and to pay damages sustained by the petitioner by reason of the malicious neglect to perform the duties of the respondent under the law, rules, or regulation. The petition shall also contain a sworn certification of non-forum shopping. The petition may be filed with the regional trial court exercising jurisdiction over the territory where the actionable neglect or omission occurred, or the Court of Appeals, or the Supreme Court. The petitioner shall be exempt from the paying of docket fees. The court may hear the case, which shall be summary in nature, or require the parties to submit memoranda. The petition shall be resolved without delay within 60 days from the date of the submission of the petition for resolution. If warranted, the court shall grant the privilege of the writ of continuing mandamus. The court shall require the respondent to submit periodic reports detailing the progress and execution of the judgment, and the court may, by itself or through a commissioner or the appropriate government agency, evaluate and monitor compliance. Essentially, the writ permits the court to retain jurisdiction after judgment in order to ensure the successful implementation of the reliefs mandated under the court's decision. For this purpose, the court may compel the submission of compliance reports from the respondent government agencies, as well as avail of other means to monitor compliance with its decision. The periodic report submitted by the respondent detailing compliance with the judgment shall be contained in partial returns of the writ. Upon full satisfaction of the judgment, a final return of writ shall be made to the court by the respondent if the court finds that the judgment has been fully implemented. The satisfaction of judgment shall be entered in the court docket. Study well, future lawyers, and see you again next time. Bye!